Hi, I'm Anthony Diosdi. I'm a tax attorney in San Francisco with over 20 years experience in international and domestic tax planning and tax litigation. You can find me at sftaxcounsel.com. Today, we'll be talking about qualified domestic trusts, or QDOT. A QDOT is a specific type of trust used in estate planning to permit U.S. citizens to transfer assets to non-U.S. spouses in order to either delay or avoid U.S. estate and gift taxes. Now, this is a relatively complicated area. I'm going to just basically scratch the surface, but I will say this is not the type of area law that someone can just kind of dabble in. This is an area of law that is quite complicated, and if you are considering doing this, you should speak with a qualified professional. So let's first start off with the estate and gift tax. What is it? And the way the estate and gift tax works is that if a U.S. citizen or a non citizen who is domiciled in the U.S. has assets in 2025 that exceed 3.99 million, a estate tax is assessed against those assets. The estate tax runs anywhere from 18% to 40%. Now, on the other hand, if you have a non-U.S. citizen who's not domiciled in the U.S., they're only subject to the estate tax and gift tax on U.S. situs property. That means property within the U.S. However, the exclusion is much lower. In that case, the exclusion for non-domiciliaries is only $60,000. Anything above $60,000 on the date of death of a non-domiciliary or non-domicile person will be subject to the estate tax. And if the person is a U.S. person, anything over 13.99 million. Now, a common ploy or a common strategy, should I say, for married U.S. couples is to go ahead and use what's called the marital deduction. The marital deduction allows spouses to go ahead and transfer assets between each other. And the assets that are transferred between each other are not subject to U.S. gift or U.S. estate taxes. Now, the problem is that if you have a U.S. citizen who transfers assets to a non-U.S. citizen, even a green card holder, even a U.S. resident, in that case, there is no marital deduction. So what happens is if there's a transfer from a U.S. citizen to even a green card holder or a non-citizen spouse, the estate and gift tax could apply. Transfers between a citizen and a non-citizen spouse, the IRS does allow an exclusion up to $190,000. Anything above that is subject to gift tax or, in certain cases, the estate tax. So what can be done? Well, what can be done is a QDOT can be set up. A QDOT can be set up where a citizen spouse goes ahead and sets up a trust, and the assets which the citizen spouse wishes to convey to the non-citizen spouse, at least for a period of time, escapes the U.S. estate and gift tax. Now, these are a little bit complicated, and there's a lot of rules that govern a QDOT, but if a QDOT is set up, there's a number of rules that have to be followed. Well, the first rule is that there has to be a transfer. There has to be a transfer of assets. And that's typically done by funding the QDOT. Once the QDOT is funded, upon the death of the citizen spouse, that goes to the non-citizen, those amounts will not be subject to the estate and gift tax. And there's a number of other rules that are a little bit more complicated that anybody who's considering setting up a QDOT should understand. And these rules are as follows. First of all, the QDOT itself has to be basically set up as a trust that is either in the United States or in the District of Columbia. It can also be set up in a foreign country, but the trust itself has to be governed under U.S. law or under the law of the District of Columbia. So that's the first requirement. The second requirement is that at least one of the trustees has to be a U.S. citizen or a domestic corporation. Cannot have a QDOT without that. The third requirement for a QDOT is that the QDOT itself has to be drafted in a way that a U.S. trustee has a right to withhold any taxes that are due to the U.S. government as a result of a transfer or a sale of an asset from a QDOT. Without that provision in the trust, the QDOT will fail. Then there is a asset test, and the asset test is $2 million. So if the value of the assets that are being transferred from the resident or citizen spouse to the non-resident spouse or non-citizen spouse exceeds $2 million, there is a number of additional rules. When I say number of additional rules, there are 3 rules. And the first rule is that the trust instrument must provide that one of the trustees is a U.S. domestic bank or a U.S. bank with a branch in a foreign country. The second requirement is that a trustee must furnish a bond equal to 65% of the fair market value of the trust's assets to make sure that the government gets paid. And the third requirement is that the trustee itself must furnish an irrevocable letter of credit, at least in the amount of 65% of the fair market value of the trust's assets. Now, it's very important to get the trust assets properly valued by a qualified appraiser to make sure that if you're over the $2 million, that there is no question, or just say if you're under $2 million, there's no question in regards to the valuation of trust. And if the trust assets are not properly valued, then what could wind up happening is the IRS could assess either penalties for improper valuing of the assets, and or they could also go ahead and terminate the QDOT. Now, when you're looking at the $2 million threshold, there is an exception to the rule. And that exception to the rule is simply this. Part of the trust assets contain a residence, a family residence, then there is an exclusion of up to $600,000 in addition to an exclusion for the furnishings of the residence itself, which would exclude that amount from the $2 million threshold. So it's important to understand the assets that are contained in the QDOT, because if you can be below that $2 million threshold, and if you use certain exclusions such as excluding a family residence, that can go a long way to reducing the cost and the complexity of establishing a QDOT. Now, there are some rules that permit a trust beneficiary to go ahead and sell the primary residence as long as the monies that are given in consideration for the purchase of the primary residence is what goes ahead and is used to purchase another home. But if that happens, there is a certain amount of reporting requirements that is required to be done by the trustee to be filed with the Internal Revenue Service. So that's kind of important to understand this rule, because that rule itself, like I said, can bring the value of that trust below that $2 million. Now, let's now talk about how a QDOT is, 1, an election is made, and 2, how it's taxed. So a QDOT, you have to set up the trust, number 1, and number 2, there has to be an election made on the decedent's federal estate tax return. So there's an election made, the trust itself is set up. The trust has to be set up prior to the filing of that the estate tax, and this also includes the extensions as well. Secondly, taxation. How is it taxed? Because a QDOT itself is taxed differently than a lot of other trusts that people utilize for estate planning purposes. A QDOT is actually taxed at the decedent spouse's level, okay? So when we're talking about the estate tax, if the estate tax itself is assessed against somebody, the estate tax either is assessed on the date of death, or there's an alternative value, which is 6 months from the date of death. But what a QDOT does is that it holds open the estate, so to speak. and the surviving spouse winds up getting a life estate in all the assets that are placed into the QDOT. So the surviving spouse has use of those assets, and the surviving spouse is also permitted to go ahead and receive income that is generated from those assets that are placed into the trust. Now, upon the death of the surviving spouse, what will happen is the assets that are placed into the QDOT will be taxed to the spouse, the original spouse who set up the QDOT. So if the value of those assets wound up going up over the number of years, the estate tax could be higher. On the other hand, if the value of those assets go down, decrease in value, the estate tax could be less. Now, what happens if an asset is sold that is contained in a QDOT? Well, if an asset is sold, and let's just say it's sold by the trustee, and it's for the benefit of the surviving spouse, you're going to wind up having a situation where there's going to be an estate tax. The estate tax itself will be due that year. So let's just say there is real estate, and the real estate is contained in the QDOT. The trustee sells the real estate. The monies from that property itself that's sold goes ahead and is distributed to the surviving spouse. One, the surviving spouse will wind up having or should say the decedent's estate will wind up paying an estate tax. That estate tax is going to be due on or before April 15th of the following year. And there's also going to potentially be an income tax consequence. And that income tax consequence itself will also wind up being due by April 15th of the following year. So the tax consequences, if you sell an asset in a QDOT, could be significant. Now, there is an exception to the rule. An exception to the rule is in a case of a hardship. If an asset from the QDOT is sold because of a hardship to the surviving spouse, and a hardship would be for education purposes, for medical purposes, training purposes, for purposes of operating the trust or upkeeping the trust. That hardship itself could defer the tax consequences associated with that, with the sale of the trust assets. So that's something to keep in mind. Now, another interesting way to go ahead and plan for a QDOT is if the surviving spouse becomes a U.S. citizen before the termination of the QDOT, then the QDOT itself terminates, and you could have a situation where the estate tax does not get assessed against the decedent spouse who originally set up the QDOT. So that is one way of potentially planning. However, if the assets are valued as such, then you could wind up having a situation that the surviving spouse winds up becoming the owner of those assets, and those assets are transferred. So these are scenarios that should be considered whenever you are dealing with establishing a QDOT. Think about who your client is, or think about what you need if you are the individual setting up a QDOT, and think about how you want those assets to be transferred. Do you want it just to be remaining with the surviving spouse, or do you want those assets ultimately be transferred to children or other family members down the road? These are all things that should be considered for when you're planning for establishing a QDOT. Now, the other thing to consider, if you are going to be a trustee of a QDOT, is that the trustee is liable for any taxes as a result of the QDOT. And this could include estate taxes or gift taxes. And in addition, the trustee itself could also be liable for any filing that should be done. And sometimes when you have a foreign beneficiary of a QDOT, forms need to be filed with the IRS, not just in connection with the actual QDOT, but other forms should be filed. Information returns to be filed to the IRS, such as a Form 1042, reporting a distribution of any type to a foreign person. And finally, the other takeaway from all this is that when you're planning for a QDOT, you need to not only plan for the U.S. tax consequences of a QDOT, but if the surviving spouse is a resident of a foreign country as well, then the QDOT itself could trigger a foreign tax liability as well. So always make sure that a careful investigation is done regarding the tax consequences of a QDOT, not just here in the US, but abroad as well. Okay, so I hope that this short discussion regarding QDOTs was useful. And I'm going to say that this was not meant to be an invitation for any type of attorney-client relationship. This discussion itself is merely for informational purposes only. And if you are considering setting up a QDOT, or if you're in need of any type of estate planning, always seek the guidance of a qualified tax attorney. Thank you.